Let's get some more analysis now. Joining me on the line is the law professor Richard Ekins from Oxford University. He also heads the Judicial Power Project in the centre-right think tank Policy Exchange. And thank you very much for being with us. And I think your position is, correct me if I'm wrong, in saying that really this whole issue of the suspension, proroguing of Parliament is not something for the courts to rule on.
That's right. It's a political question, and the High Court recognised that below. In our law, the prerogative to prorogue Parliament is a question for the Prime Minister, for which he is accountable to the House of Commons and eventually to the electorate. And there's no space here, there's no need for judicial intervention, and in fact the law, and I hope the Supreme Court recognises this, the law does not permit them to intervene.
Well, that is what's been debated over the last 3 days, as you know. I'm sure you've been following it. But I mean, one of the questions, for example, that's been raised by actually one of the justices was, OK, well, what if a Prime Minister then wants to prorogue Parliament for a year? Or what if a Prime Minister wants to effectively disband the army by proroguing Parliament? That kind of thing. Those sort of hypothetical examples, but they are quite important.
Well, it's a familiar line of argument, but it fails to recognise, I think, that in our Constitution we rely on political controls to prevent a great many different abuses. And it would be political suicide for a Prime Minister or a government to attempt to dispense with Parliament for a very extended period of time. And they'd run into enormous legal difficulty in terms of securing changes in the law and especially support for taxation and spending, which would be needed to govern, as well as the fact they would be destroyed in the coming election. The political controls are a central part of our Constitution. They control all sorts of central government powers, like foreign policy, waging war, dissolution of Parliament before 2011, and prorogation.
But the central argument here is that Parliament, because of being prorogued, because of being suspended, was deprived the opportunity to scrutinise the executive at an absolutely critical political time in the history of this country.
Look, it's a good political argument, and its proper place is the political arena. And the House of Commons did have an opportunity across 8 or 10 days, 8 days I suppose, to withdraw confidence from the government if it chose to. It could have brought about a dissolution and an election on that basis, and it decided not to.
I hear what you're saying, but other people will say all of this is such a grey area because of our unwritten constitution. We don't know exactly where we do stand. And it's a question of balance of powers between, the Parliament and the government and the courts. But it shouldn't be this unpredictable in a sense.
Well, I agree it shouldn't be unpredictable. And in a way I would have said it wasn't unpredictable. The law does not permit judicial review of the prerogative to prorogue Parliament. It's subject to political control. Now that obviously does leave space for a serious political controversy, a disagreement between MPs in the House of Commons and the Prime Minister. And eventually that has to culminate in an election.
All right, Richard Ekins, we're going to have to leave it there because we're back on inside the Supreme Court. Let's listen to the